Hi there, this is again the last and short volume of my video course regarding data protection. I'm very happy that you followed me so far, although my German English accent leads to a situation where it's difficult to understand me. In the last session we will talk about the implementation and reactions in Germany regarding the GDPR. So, let us start with the outline. We talk about the relation between German and European data protection law. We talk about the very old and 3-time refreshed BDSG, Federal Data Protection Act, and we talk about sector-specific regulation, a big problem in Europe. It's quite easy how the Germans reacted in seeing the GDPR. They simply said yes, and that's all. So the GDPR applies directly to Germany within the meaning of Article 288 of the European Treaty. So Germany could only have isolated regulations in certain gaps where the GDPR allows national ways. So we had in Germany a very old Federal Data Protection Act from 1978. Then we had a refreshment in 1989, and the last time we made it new in accordance with the GDPR. The BDSG transposes mandatory and optional opening clauses of the GDPR into German law. So you find general provisions, the implementation of the GDPR, and specific provisions regarding criminal prosecution. What we are proud is, what is a part of our tradition, is the implementation of data protection officers. They are working internally and independently in each bigger company. So each bigger company must have one independent data protection officer who is helping the chef of the company in implementing data protection. We have a variety of data protection supervisory authorities. We have specific rules for sensitive data. This data protection officer that's expressly regulated in the GDPR, which allows for member state specific rules regarding the necessity of data protection officers, and that leads to the German Federal Data Protection Act, which stresses even more than in former times the need to have an internal data protection officer. We have a variety of data protection supervisory authorities because Germany is a federal state with minor countries, so-called Bundesländer, and these Bundesländer are responsible for supervising data protection done by private companies. So private companies have to carefully choose in which Bundesland they have their seat because the state data protection commissioners might have totally different views compared to each other. We have one federal data protection commissioner, but he is not only responsible for telecommunication and data protection law and for the federal state agencies. So the BDSG has still some importance and uses and mitigates sometimes the harsh standards of the GDPR. Then is an additional problem, the sector-specific rules, because in telecommunication and data protection we had a Telecommunications Act with specific rules, harsh rules, and we don't have clear rules from Brussels, from the European Union, because the European Union had a e-privacy directive which was very, very old, which regulated, for instance, that cookies can be done in the internet unless the person concerned contradicts. All attempts to have an e-privacy regulation have not succeeded. We still wait for an e-privacy regulation to come, so that the questions like data protection in the Internet of Things, in telecommunications, in automated cars are still open for discussion. So, thank you very much for listening to me so carefully. That was the last session. Perhaps I do follow-up sessions and follow-up videos. Again, thank you for all your patience. If you have questions, do not hesitate to contact me via email. I will answer any question.